A few weeks ago, we read a chapter on copyright and Creative Commons licenses. It fascinated me. I didn't understand what copyright was other than the ability for an author to get paid for their work. One question I've wondered often is, why is the Bible copyrighted? In short, I found out it has to do with the translators getting paid for their work, but that's a whole other subject. The ALA, which is the American Library Association, has a code of ethics which states, "We respect intellectual property rights and advocate balance between the interest of information users and rights holders." So what is copyright? Well, a law in the U.S. Constitution states that it is used to promote the progress of science and useful arts by securing for a limited time to authors and inventors the exclusive right to their respective writings and discoveries. So an idea cannot be copyrighted. It must be a fixed medium, like a play, song, or even a poem. It doesn't matter if it's published or unpublished. Also, artwork such as a sculpture, painting, or photograph can be copyrighted. Now, after a copyright expires, the work will enter the public domain. Since January 1st of 1978, this does not happen until two things occur. First, the author's death. Second, a period of 70 years since the author's death. Now, why is this important? The reason is because without the protection of copyright, works can be distributed without having to pay royalties to the author. If you've ever walked into a Walmart, Target, Best Buy, any place that sold movies, you could usually find multiple DVD versions of It's a Wonderful Life or Night of the Living Dead. The reason for this is because somewhere along the way, someone failed to renew the copyright for those films, and thus they entered the public domain. Now, there are exceptions to copyright, like the first sale doctrine. This allows the owner of the copyrighted work to sell it to another person or dispose of it as they wish. They cannot, however, make copies of the work with the intention of distributing it for profit. They cannot even make photocopies of it for free, as it infringes on the copyright of the author. The ability to reproduce copyrighted works in copies or phonorecords is one of the 6 exclusive rights held by copyright owners. This is one reason why VHS, cassette tapes, CDs, and DVD-Rs are been so controversial. They allow the user to copy a work and distribute it. Fortunately, there is what is known as the library exception, or if you want to get technical, Section 108 of Title 17. A library is considered to be an information organization, and as such is allowed to create 3 preservation and replacement copies. Now, when a library does make a copy, they need to make sure it falls under fair use, and there are 4 factors that guide their decision. First, the purpose and character of the use. Secondly, the nature of the work. Third, the amount of portion used. And lastly, the effect of the use on the potential market. Now, a library, whether it be public or private, must know about copyright law and what they are allowed to do for their patrons. As technology has rapidly evolved, copyright law is trying to catch up. Scholars need interlibrary loans, and in the early 70s, this required making copies of the work and sending them to various campuses. CONTU, which is the Commission on New Technological Uses of Copyrighted Works, was established in 1974 to study the use of copyrighted works on computers and other machines. Now, the 1976 Copyright Act was designed to protect analog and, dare I say, physical works. Now, for students currently, much of our scholarly resources are now born digital, never having a physical analog counterpart. The Digital Millennium Copyright Act was designed to prohibit works from being transferred from one media format to another, like a DVD to an MP4. Yet this can be problematic, as a library is allowed to do so on good faith determination. Now, if the work is that of the U.S. government, then it is automatically public domain. Something similar to this is the Creative Commons license. The Creative Commons organization was founded in 2001, and it is beneficial to libraries as their intent is to make it easier for the creator to open their work up to public use while still retaining their copyright. My first experience with Creative Commons license was not with a library, but with music. In 2008, Trent Reznor of Nine Inch Nails allowed his recent album, Ghosts 1 through 4, to be distributed by ways of a Creative Commons Attribution Non-Commercial Share-alike license. This meant that others can share and adapt content, but can only use the content for non-commercial purposes. Users must provide credit to the creator and link to the license and provide notices of changes made to the content. If the user adapts the content in any way, they must use the same type of Creative Commons license for new material as was used for the original content. So the purchasers of this music were allowed to remix it and distribute it, or create videos for the content as long as it wasn't for profit. Now, the library is an ideal. It's an institution that is devoted to connecting people to ideas. Many library associations have in their value statements the term a public good, meaning the library is here to serve a public good. The ARL, which is the Association of Research Libraries, Intellectual Property Statement of Principles, similarly states that copyright exists for the public good. Now, the spirit of the copyright is not about creating a business model or providing financial gain for the author. Both copyright and libraries serve to benefit the public to an access of ideas previously unattainable to them. So therefore, it is in their best interest to find common ground so that they may continue to bring ideas and information to the public.